All right, hey guys. So we are back. We now have Lively's reply to the spoliation opposition from Wayfarer. I just uploaded the Jones Works reply, and then after I've done this, I will be doing Jones Works. Stephanie Jones's. She's basically requested leave to file an amended complaint. I completely forgot why she needed to do that, but then I remembered when I was reading her spoliation reply, I was like, oh yeah, a lot of her complaint got dismissed without prejudice, so she was able to refile her claims against Jen Abel. So I will be going over that after this. Okay, so Blake Lively's reply regarding the spoliation sanctions. In their opposition, defendants admit that they took no steps to preserve ephemeral communications prior to December 20th, 2024, and that these communications have been irretrievably destroyed. Again, Blake Lively didn't request that anyone preserve communications before December 20th, 2024. The ephemeral communications facilitated a means by which defendants could speak quickly, candidly, and most importantly, covertly, as Melissa Nathan acknowledged. When we send over documents, we can't send over the work we will or could do because that could get us into a lot of trouble. Like, Melissa Nathan wasn't talking about Signal in that text. None of defendants' excuses for their failure to preserve past muster. First, defendants' argument that they anticipated litigation only as to Miss Lively's harassment claims but not retaliation is entirely disingenuous and plainly wrong on the facts and the law. It ignores the fact that in the November 9th, 2023 protections document, Miss Lively cautioned Wayfarer against retaliation in its many possible forms, including changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work. I had a big problem with that that kind of clause in that 17-point document, because changes in attitude, sarcasm, any other negative behavior, either on set or otherwise. I mean, how subjective is that? Lively is look at the way she's treating the whole sarcastic joke from Brian Friedman about, well, we can take her deposition in Madison Square Gardens and raise money for, domestic violence survivors. It's clearly a joke, but she is taking that so seriously. And she knows it's a joke as well. She knows what she's doing, but she's using it for everything she can, including emotion, to be able to dictate where she has her deposition taken. So you can imagine how Lively would abuse that kind of clause, which is so wide open. Like if Justin Baldoni come in, had a bad day, had lost a family member or something, Lively could literally say, right, you've changed your attitude, that's it, it's retaliation. And suddenly he's on the hook for all of the crap that we've seen her try to claim, including the treble damages, etc., and everything that goes with that. I don't like that, and I think it's such an absurd clause to have in a contract. Okay. I'm going to just go over that bit again because I'm losing my temper already with it. It ignores the fact that in the November 9th, 2023 protections document, Miss Lively cautioned Wayfarer against retaliation in its many possible forms, including changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work, and warned such conduct would be met with immediate action. Instead of heeding this warning, defendants treated it like a roadmap and promptly set about retaliating in each of the ways described. Oh my God. The protections document which each defendant received. I mean, that's not strictly true. It's not. Jen Abel didn't receive it from Lively. The fact that she was passed it on by someone else does not mean that she is now bound by it, though. Jed Wallace, same. Melissa Nathan, same. Tag, the same. Along with others referenced in the motion, provided as much notice of potential litigation on the issue of retaliation as it did of harassment. Second, in a cynical attempt to benefit from their own misconduct, defendants argue that Ms. Lively has failed to demonstrate the contents of the destroyed ephemeral communications. But Rule 37E does not require such a showing, nor could it, since it would enable bad actors to avoid liability for their wrongdoing by using their own destructive activities as a shield. Obviously, the contents cannot be demonstrated because they were destroyed. That's the whole point. Third, defendants argue that Ms. Lively has not suffered prejudice because she noted there is substantial evidence of retaliatory conduct, and as such, the lost communications would be unnecessarily cumulative. But defendants ignore their own repeated and loud proclamations that they did nothing to further any digital campaign and were only monitoring if unchecked. They could describe this monitoring in whatever way they want, safe from the risk of impeachment by contrary documentary evidence, having conveniently destroyed it. This is textbook prejudice, which can only be mitigated by limiting instruction. Finally, defendants' argument that they lacked the requisite intent ignores each of their own admissions, that they anticipated litigation no later than August 2024 and took no steps to preserve these destroyed communications. In fact, defendants confirm that at any point signal chats could have been preserved with the flick of a switch. Their decision not to was deliberate, and the very reason they used signal warranting severe sanctions. The undisputed record confirms each defendant had a duty to preserve ephemeral communications and no reasonable steps were taken. Defendants' opposition confirms they took no steps to preserve their ephemeral communications. Instead, they argue that they had no duty to preserve. This argument not only ignores settled Second Circuit precedent, but also Ms. Lively's unrebutted evidence. Among other things, defendants do not dispute and therefore concede that Wayfarer, It Ends With Us, Baldoni, Sarowitz, Heath, and Abel received the protections document in November 2023, and that the protections document constituted a demand letter for preservation purposes. There's a footnote here. At several points in their opposition, defendants boldly claim that their agreement to the protection resolved the issues that had arisen during Phase 1 and eliminated the threat of potential litigation. These claims are not supported by any facts or evidence and are plainly undermined by the underlying interrogatory responses. They admitted that litigation was possible in or around mid-August 2024. These admissions confirm that by no later than mid-August 2024 and as early as November 2023, a duty to preserve was triggered. None of this is contested by the defendants. Rather, the crux of their argument rests on the dubious assertion that the only litigation that could have been anticipated in August 2024 involved Lively's objections in Phase 1, which somehow excuses them from any preservation obligations. This argument is simply baseless. First, defendants' contention that their duty to preserve was limited only to Ms. Lively's harassment claims finds no legal support. In fact, they cite no authority for this extremely narrow interpretation of the duty to preserve. Nor could they. Courts within this circuit have repeatedly recognised that this duty is a broad concept that applies to all relevant documents, which in this case would clearly encompass Miss Lively's retaliation claims. Second, any actions taken in response to the protections document and communications relating to the anticipated plaintiff, Miss Lively, should have been preserved. Illustrating this point, during a July 25, 2024 meeting between TAG and Wayfarer, specifically defendant Heath and Tara Hanks, Wayfarer discussed, among other things, redacted. By July 24, 2024, defendants were still discussing Miss Lively's harassment claims, now in the context of a crisis PR strategy designed to proactively prevent defendants Baldoni and Heath from being redacted. And because retaliation was plainly an issue that defendants were warned would be the subject of any litigation, they cannot now pretend they did not understand that in the midst of undertaking the precise retaliatory conduct about which they had been warned, right? Okay. In fact, they understood the risks perfectly well, which is why they repeatedly stressed the need to avoid putting things in writing, and further why they moved to signal, to cover their tracks and avoid creating a litigation record. Finally, defendants argue that there is no evidence that prior to December 20th, 2024, Nathan had reason to anticipate litigation involving her crisis management activities on behalf of the Wayfarer defendants. This argument ignores the fact that, one, by early June 2024, Wayfarer was assembling a timeline doc of each alleged incident that involved Miss Lively, as well as zingers intended to attack Miss Lively's reputation. This document, which is effectively a litigation roadmap, it's not, was provided to TAG, Abel, and Nathan on July 30th, 2024. 2. The TAG defendants were aware of Miss Lively's harassment complaints by June 17th, 2025, when the TAG defendants received a copy of the protections document, and no later than July 25th, 2024, redacted. 3. The TAG defendants themselves acknowledged that litigation was anticipated by mid-August 2024 and knew that they needed to cover their tracks. And 4. TAG defendants were responsible for facilitating meetings with Mr. Friedman when litigation was forthcoming. The retention of counsel in itself is not evidence. The fact that Friedman was, put in touch with Wayfarer and communicating is not necessarily evidence that Wayfarer were anticipating litigation. I'm not arguing in general that, there's not other evidence that they were, by August, starting to anticipate litigation. But Friedman being brought on is not in of itself evidence. You consult attorneys and lawyers for all kinds of things, not when you're about to be sued or when a situation might go to court. You get advice. How do I handle a situation? How should I respond to this? To safeguard yourself from saying or doing something that might lead to litigation. You use law firms to avoid litigation as well as to kind of, prepare for it. Ignoring all relevant context, defendants argue that there is not a whit of evidence that the war referenced by Ms. Nathan was linked to Lively's discrimination claims. But defendants admit from their papers that this reaction to go to war was made in response to Miss Lively's request that defendants Baldoni, Heath, and Wayfarer issue a public statement apologising for their misconduct on set. I'm glad to see that she admits that she did that. Which followed a vicious and viral online hate campaign directed not just at Miss Lively, but other female cast members. What? Not directed not just at Miss Lively, but other female cast members. That was confounding given the film's remarkable box office success. What? I thought her story keeps changing. Initially, when she started this, it was all retaliation against Lively, her husband, and her family and her businesses. Now, since the motion for summary judgment response has come in, it is being Lively and all of these female cast members. I saw a lot about Lively during the marketing period, but I saw a lot about Lively even being offered the role. People did not even like that. And that was before any of this. Her marketing was awful, specifically her marketing. The stuff she was saying, her actions were problematic. But I saw absolutely nothing about the other female cast members. That's just absolute nonsense. There's a redacted text message from Ableton Nathan. That's just wild. That is just absolutely wild. The undisputed record establishes that each defendant used Signal and that ephemeral communications once existed. Defendants attempt to pass blame onto Ms. Lively for purportedly failing to demonstrate that defendants deleted Signal chats, evidencing that they executed the public/relations/crisis management strategy. But defendants' argument on this score turns Rule 37's standard on its head. Ms. Lively is not required to provide the contents of the communications defendants destroyed, but only their existence. Indeed, in Barbara, this court issued spoliation sanctions under Rule 37E1, notwithstanding that the nature of the deletions makes it impossible to identify with certainty what documents were destroyed. Put simply, the application inquiry here is whether the relevant ESI existed and was destroyed. The answer to each question is yes. There is overwhelming proof that defendants spoliated communications. Each defendant admitted to using Signal to discuss, among other things, the digital campaign, whereas those interrogatory responses are. Further, the Wallace parties admitted to the existence of these communications and further explained that by operation of Signal's auto-deletion settings, any potentially responsive messages were deleted as a matter of course. This court has already found that it is undisputed that the Wayfarer parties used Signal to discuss topics relevant to this litigation. Discovery has only bolstered this court's prior finding. 1. In party productions, documents were produced demonstrating the creation and use of Signal threads to discuss issues relating to the retaliatory campaign as early as August 7th, 2024. And 2. At their respective depositions, defendants Heath, Nathan, and Abel each testified to using Signal during the relevant period of time. Right, that's not entirely true. I have read Abel's deposition on this. She admits she was added to a thread, but nothing was ever said in that thread. These facts render the entire laundry list of cases cited by defendants inapposite, each of which turned on the movement's failure to demonstrate the purportedly spoliated documents even existed ex ante. Ex ante, it's a Latin term basically, and it means calculated or something existed before a particular event. It's the opposite of ex post, which is, actual after. Ex ante is Spoliation has prejudiced Ms. Lively. The evidence shows that defendants, along with the Wallace parties, turned to Signal in or around mid-August 2024, at the same time the digital campaign was underway. The few documents that were preserved and produced by the Wallace parties illustrate their abilities to, among other things, manipulate social media engagements and website traffic for clients, as well as how easily they were able to conceal their hand in those efforts. That the key ephemeral communications, including those with the Wallace parties, were not preserved, establishes clear prejudice to Ms. Lively and deprives her of the ability to test and rebut the counter-narratives that defendants have continued to advance. Hold on, we got a footnote here somewhere. Oh, there's a footnote back up here, right? Back where the bit where she claims Abel testified to using Signal as a footnote. As for Baldoni, he testified that he used Signal to talk to a support group prior to December 2024, but the evidence in this case has shown that he sent text to his support group directly about the harassment allegations in November 2023 and January 2024 at minimum. It defies reason to suggest that he was talking with a support group in the fall of 2024 on Signal at the height of this dispute and never once discussed Lively. I mean, again, that's speculation. So the text messages she has included there are the ones where he was texting people like Rainn Wilson the day after the Penthouse showdown. So the fact that, yes, he was sending direct messages directly does not mean that he wasn't using other kind of messaging platforms. You know, I might send a message to someone on Messenger, but I might also send them a text message or a message on X as well. You know, it just depends where I am and what's easier. Okay. In their opposition, defendants do not address the examples of prejudice identified by Miss Lively. Instead, they focus on the substantial evidence referenced in the opening brief and argue that this somehow rebuffs the notion of prejudice. We have a footnote, check it. Defendants improperly shift the burden to Miss Lively to demonstrate prejudice. However, it is well settled that it is not plaintiff's burden to prove prejudice. Okay. But again, defendants miss the point. They have compromised Miss Lively's ability to rebut and refute defendants' defences. This is especially so with respect to their assertion that the only work they were doing is monitoring, which courts, including this court, have recognised as establishing prejudice. Miss Lively has been deprived of the digital trail that would allow her to test, counter and contextualise defendants' insistence that they did nothing other than monitoring. Finally, relying upon Rule 403 of the Federal Rules of Evidence, defendants argue there is no prejudice since the ephemeral communications that they failed to preserve would be needlessly cumulative. There's a footnote. Defendants' reliance upon the Federal Rules of Evidence is entirely inapplicable to evaluating prejudice under Rule 37E of the Federal Rules of Civil Procedure. But the loss of needlessly cumulative evidence in and of itself supports a finding of prejudice. Okay. The Wayfarer parties are responsible for the Wallace party's spoliation. What? Okay, this should be good. The Wayfarer parties attempt but fail to relieve themselves of responsibility for the Wallace party's spoliation. Courts in this circuit have held that a party may be liable for spoliation based on the actions of a non-party within his or her control. Okay. Right. The court's decision in Ronnie Van Zandt is instructive. There, the court determined control was established for spoliation purposes where the non-party one was contracted to work for the defendant on a film underlying the litigation. 2, had been working closely with the defendant for over the past year. 3, actively participated in discovery. And 4, had a financial interest in the outcome of the litigation. Okay, well, some of that does not actually apply to Jed Wallace, does it? Like, he was contracted to work for Wayfarer after a film, not on the film. He hadn't been working closely with Wayfarer for over the past year. It was 3 months. I wouldn't go as far as to say he actively participated in discovery. He did try to stay discovery twice and, argued against several motions to compel. He was forced to participate. He didn't voluntarily do it. And 4, what financial interest did he have in the outcome of litigation? He was being sued. So I don't know how that applies, but there we go. Upon finding control, the court held that spoliation sanctions were appropriate against the defendant based upon the non-party's actions, which included getting a new phone after plaintiffs brought the instant action and managing to back up pictures but somehow not text messages. Here, the relationship between Wayfarer and the Wallace party supports a similar common sense finding that the Wallace party's ephemeral communications were within Wayfarer's control. Among other things, 1, Wayfarer hired the Wallace parties to support Wayfarer's crisis team. 2, Wayfarer paid the Wallace parties for their redacted. 3, Wayfarer and the Wallace parties share the same counsel, Liner, Friedman, Titleman, and Cooley. 4, Mr. Friedman has been the Wallace party's lawyer, redacted. 5, Wayfarer is redacted since at least August 11th, 2024. Wayfarer knew of Wallace's use of Signal. As such, the Wayfarer parties should remain liable for the Wallace party's separate spoliation. That is a very weak argument, in my opinion. They got the same counsel. Oh my god. It's my understanding that I don't know. I'm not 100% sure, but I mean, Friedman and Jed Wallace have a prior existing friendship and relationship. He joined forces with them at the very start of the litigation, and yes, we have established that Wayfarer is paying what the Wallace party's counsel fees. So I'm talking about Charles Babcock here now, but still. That is like, that's not as much of a link as I would expect. Just my opinion. Okay. Defendants ignore almost entirely the evidence presented by Ms. Lively that demonstrates their intentional use of ephemeral communications as part of their untraceable plan. Oh, untraceable's back. The last document was no fingerprints. Instead, they point to steps they took to preserve Signal communications after December 20th, 2024, as disproving the notion that they acted with culpable intent. Defendants admit that they were always capable of preserving these communications, but only began taking the appropriate preservation steps once the lawsuit was filed. This does not excuse them of wrongdoing, but is in fact further proof of their conscious dereliction of a known duty to preserve electronic data. I've got a footnote here that I didn't see. I must have missed it at the point it. Oh, okay, it was at the title. Okay, footnote. In their opposition, the Wayfarer parties commit 2 separate sections to addressing the requisite intent for sanctions under Rule 37E2. Miss Lively addresses these arguments together. Okay. Further, the unrebutted record unequivocally demonstrates that defendants acted with the requisite level of intent for purposes of Rule 37E2 sanctions. Each of the factors identified by Moody are established. 1. Ephemeral communications existed and would have been relevant to this dispute. 2. Defendants took no steps to preserve their ephemeral communications despite anticipating litigation. And 3. There is no credible explanation for the lost ephemeral communications as not involving bad faith. The timing of defendants' use of signal communications removes all doubt as to bad faith. By mid-August 2024, defendants' new litigation was reasonably foreseeable and made the deliberate decision to then communicate through ephemeral channels. In fact, they expressly acknowledged the need to cover their tracks, knowing that documenting their actual work could get us in a lot of trouble. This demonstrates bad faith. If defendants were truly engaged in run-of-the-mill PR work, there would be no reason to think that their activities, if exposed, could have gotten them in a lot of trouble. Instead, their own documents confirm that an integral part of the crisis management strategy was that it be executed without fingerprints. Defendants used ephemeral communications as part of their retaliatory digital campaign so as to avoid being used against them as part of a legal claim. This is precisely the type of misconduct Rule 37E2 is intended to address. For the foregoing reasons, Miss Lively's motion for spoliation sanctions should be granted. Do you notice this lady is really going to great lengths to accuse someone of deliberately deleting evidence when she tried to allegedly threaten Taylor Swift to delete text messages between them that would have been, incriminating, under the threat of, if you do not do this, then I am going to leak 10 years of our text messages together. All your secrets will come out. Oh, Lively. Right. All right then. I will be back in a bit then with Stephanie Jones's amended complaint. Can't wait to see what that says.